We are live, Mr. Chairman.
Thank you very much. It's March 31st. This is the House Judiciary Committee, and we have bill hearings today. Many of them are going to be, several of them are administration bills. We're probably going to hear from staff as well, because the senators are still on the floor in the Senate. So why don't we get underway with Senate Bill 172. Andrew Tress here to speak for the Department of Juvenile Services. And there is Mr. Tress. Going to hear from him for 3 minutes. It's a departmental bill. Go ahead for 3 minutes on 172.
Thank you, Mr. Chair, Vice Chair, members of the committee. For the record, my name is Andrew Tress, Legislative Director for the Department of Juvenile Services, and I'm here in support of Senate Bill 172. This is a simple departmental bill. It's more of a cleanup bill than anything else, and it makes two alterations to the Maryland Code. The first is that it removes the Carter Center from the list of DJS committed facilities. This facility closed on June 30th of 2020. It was an all-girls hardware secured committed treatment program located in Chestertown in Kent County, Maryland. Girls that require placement in an out-of-home treatment program are currently served in the community or through privately contracted programs. This closure aligns with the downward trend we've seen in our committed population over the years. And it's also important to note that no DJS staff were fired or laid off as a result of this closure. Instead, they were relocated to other facilities or filled needs in the community. The second alteration is it removes the term train from the services provided in DJS operated detention and committed facilities. This is an unnecessary and sort of outdated term. The educational programming that's currently offered in all of our facilities already includes career, job, and workforce development. The term isn't needed. This bill passed unanimously with one excused out of JPR back in January. For all these reasons, I urge a favorable report, and I'm happy to answer any questions.
Questions? Delegate Bartlett.
Thank you, Mr. Chair. Thank you, Mr. Tress. Good to see you.
You too.
Quick question.
Delegate Toll.
Okay.
Delegate Tolles. Thank you. Delegate Bartlett.
Thank you. Just a quick, there's a detention center, a young girls detention center that closed in my district, Waxter. I want to know, is it the plan of the department to, and the one that you're mentioning closed in 2020, is it the plan to update the law, center by center, or are we going to get like a whole list at some point and just do them all at one time?
I will.
Beyond this one.
I guess it's sort of hard to say for sure, but I mean, as of right now, it's a good chance given that the Waxter closed sort of like leading right up to session, actually. Yeah. So it didn't really fit into putting it into this bill. So as we close, I'm sure we would put it in sort of, as needed. I don't anticipate a sort of a long list in our capital projects. We do have a few other facilities that are currently scheduled for closure, but as we all know, that can change if, depending on population trends and whatnot, but I hope that answers your question.
It does. Thank
Okay.
you.
Mm-hmm.
Delegate Cardin.
Thank you, Ms. Chair. Thank you, Ms. Tress, for coming. We had a conversation earlier in the session regarding getting information from juvenile services on peace orders and how they are, in fact, being implemented, particularly for juveniles. I mean, we didn't pass my bill because we just were going to amend it to be informational. I haven't heard anything from Department of Juvenile Services, but I'm thinking that maybe an appropriate amendment for this would be to put in a requirement to have just a report if this is really technical. This bill is technical in its nature, maybe to have that information be included about how peace orders are being implemented. Is this not an appropriate vehicle to do that?
We're certainly not opposed to doing that. I mean, in fact, we've already, since, the introduction of your bill, which, thank you for that, we're going to start incorporating into our annual data resource guide data that we collect on peace orders and provide more information sort of on that process as part of that annual reporting document. So I don't know if it's the exact posture for this bill, but we're more than happy to provide any information on that process and data that we have available leading up to next year's data resource guide, and whatever information we can help, we're happy to provide.
Yeah, and just to remember that bullying and using peace orders as a defense against unnecessary harassment and tormenting of children is really important, especially even if the children are not involved in the juvenile system. So,
yes, sir.
We do need that information to make sure that we are going to adhere and make sure that we're protecting these young people.
Yes,
Thanks.
sir. Agreed. We certainly will. Thank you.
Delegate Cox.
Thank you, Mr. Chairman, and thank you, Mr. Tress, for appearing today. Real quick, two questions. The first one is, do we have any high security facilities left in Maryland for female youth?
Currently, most of the youth or the female youth that are in committed treatment programs. So I guess the short answer is no. We utilize either youth for females or either placed in the community, and if necessary, there we usually will put them within our state contracted programs, and as a last resort, out of state contracted programs.
And those contracted programs are with families or back in the homes that they came out of, or it's not a state facility, in other words, correct?
It can be group homes. Some are state facilities, some are not, some are private contracted.
And these are low security. So in other words, they're housing, modern housing that may or may not have fencing and all the modern security features that we see in some of the other facilities.
Yes, I believe some of the securities vary in their level of security. I would have to get a formal answer and look back at exactly which ones the security levels are for each. But yes, it does vary.
So is there a place I can find a report for any violent offenders that in terms of their placement? Is there a department report on that? Similar to, I guess, the question from Delegate Cardin, finding more information on these issues.
Well, in the data resource guide, we'll have per county and statewide for what, for each county where what crimes were committed and where kids were placed. So, but we're more than happy to, that's sort of like laced throughout various parts of the data resource guide. So I'm more than happy to sort of compile some of that for you and get a little bit more specifics.
If you could and email that would be fantastic.
Yeah, no problem.
Last question was, what's the future of the Victor Cullen Center in my district?
The Victor Cullen Center is, that no current plans are in place to alter, remove, or close or do anything to that facility as it stands.
Okay, thanks so much.
No problem.
Delegate Crutchfield.
Yes, thank you, Mr. Chair. And hello, Mr. Tress. Thanks for being here. Appreciate you as always. Can you tell us how many hardware facilities there are for children in the state of Maryland?
So hardware for secure, I believe, let me just look on my list here. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay.
And are those dedicated, or any of those dedicated to young ladies at all?
No, I mean, we will have female youth in detention, right? So like today, as of today, currently there's 10 females in our detention facilities, right, which are hardware secure, right? And then in their committed programs, there are no females in there currently. However, there are 8 female in-state contracted and 3 in out-of-state contracted.
Okay. And can you tell us why that is, why we don't have female specific hardware facilities? Is it because we don't have young ladies committing crimes in which that is required, or can you just elaborate a little bit more?
Sure. And, I might be able to get a little more specifics, but in general, yes, our female populations are traditionally much lower than our male populations. And many of those cases that are brought in via complaint through the police, majority of the time, are usually informal. I think actually in fiscal year 2021, out of the 64%, about 1,800 complaints that came in, this is female specific, 64% of those were resolved and had no jurisdiction at that point. Resolved at intake or informally adjusted was another 12%. And sort of those, another 25% were dismissed or null prost. So if you sort of started pare down those numbers, it's a very low population and the resources are better available in our in our contracted programs.
Thank you very much, Mr. Tress.
No problem.
Are there further questions on Senate Bill 172? Seeing none, we thank you very much. And that concludes the testimony on Senate Bill 172. Members of the committee should be aware we're going to stop at 2:20 because we have to go to the floor at 2:30. Senate Bill 214, we're going to hear from Denise Conway. if Denise Conway is here. All right, we have Denise Conway. And we're going to hear from her for 3 minutes on Senate Bill 214. Then we're going to go to Senate Bill 668 out of order so that we can hear from Judge Jensen. So it's 214. Ms. Conway, please, for 3 minutes. Ms. Conway? Ms. Conway? All right, Ms. Conway appears to be having problems connecting to audio, so we will go to 668 now. We're going to go to 668 right this second. We'll hear from Judge Jensen from Caroline County. If we could have Judge Jensen brought in, please. Judge Jensen, that's fine. We'll come back to 214 in a second, but we're going to hear now, hopefully. The creek don't rise. Mercifully, perhaps. Seriously. All right, let's see if Judge Jensen will get on. We have Ms. Conway, but we need her to wait. So here's Judge Jensen. Great.
Hi.
3 minutes, please. Judge Jensen on Senate Bill 668.
Greetings from Chestertown. I'm Karen Jensen. I'm a senior judge with the state's judiciary. Sat in Caroline County from 99 to 2016. Since that time, as a senior judge, one of my responsibilities is presiding over the truancy reduction program here in Kent County. I know that Judge Kent from Worcester County may have addressed you all previously, but I was asked specifically to address a concern that truancy courts may be contributing to the school to prison pipeline. And I'm here to emphatically say that, at least in my experience, is not true. First, just to remind you all that these truancy petitions are akin to like a civil citation. It is not a petition for juvenile delinquency. It's not even a petition for child in need of supervision. These are civil cases that do not result in a finding of delinquency or supervision for a child. There is no juvenile record. It is not criminal court. I can't send parents to jail because they're not sending their kids to school. It is a problem-solving court that, in its best tradition, works collaboratively with the family, Board of Education, and other community partners to figure out what the barriers are that are preventing the kids from going to school, and to work with the families to find solutions so the kids want to re-engage with school and go to school. Here in Kent County, we have about an 85 to 88% graduation rate. Our program is small compared to others, max about 45 kids. Demographically, it's 50-50 males, females. Pretty much a split between Caucasians, Blacks, and Latinos. Kent County, maybe to be surprising to some, is not a county with 100% of affluence. There is a lot of families with a lot of challenges here, socioeconomic challenges, and the program works really hard to work with the families to address all these needs. I can say that from where I sit in my experience for the past 5 years, this program does everything we can with our community partners to prevent what may be a child ending up in juvenile delinquency court, because our goal, as stated in the bill, is to re-engage these kids so they get the education they deserve. My speech to all my families always starts with what truancy court isn't. And as I've just described to you, I tell them it's not juvenile court, cannot remove a child from their home. I can't place them in any type of detention. Juvenile services actually is not even involved in the cases at that point. I also explained the kids don't get records. I explained it's not criminal court. just to sort of point out the collaborative approach to the truancy courts. Again, Kent County's small. We're really fortunate to have a good partnership with our local management board and the various services that can be pulled into what we call local care team meetings. I can think of one young man, middle school, terrible time in going to school. We were able to plug in some services through the local management board, including
Your
a home
Honor, we're going to
assessment.
need you to begin to wrap up, please.
I'm wrapped up. If you have any questions, I'll be glad to answer them.
Thank you. We'll go to Delegate Cox.
Thank you, Mr. Chairman. Thank you, Judge, for being here. It's an honor to see you today. I just want to ask you quickly,
Yes.
this program that you are sponsoring and leading in, thank you for that. But this is actually the method, or a wonderful primary method, to prevent the prison to pipeline issues, the prison pipeline issues, as we discuss in this committee quite a bit. I mean, is that your understanding?
Yes.
Excellent. Well, thanks for your service.
Thank you.
There are other questions? All right, seeing Delegate Bartlett, are you asking a question? Okay, Delegate Bartlett, go ahead.
Thank you, Mr. Chair. I couldn't find my button. Hi, Your Honor. Do you
Hello?
have any data on that statement you just made?
The data of what? What statement?
That it actually reduces the prison to the school to prison pipeline?
Well, I guess the flip of that is there any data that indicates any of the kids in our program end up in juvenile court? I could probably get you that data, but I can tell you, just based upon my knowledge of the kids, I can think of only 1 out of 5 years that ended up in juvenile court because they committed a delinquent act.
Really
Yes.
quick question.
Uh-huh.
When a child is in truancy court, do they go more often? Can they go each time that they are referred, or is there like a cutoff on how many times you can be referred?
Refer them to-
and are they out of school when they go into truancy court?
Okay. With respect, they can come through the program as many times as the board brings one of these petitions. I've had repeat kids. So yes, they can come back. They see me as frequently as I believe and the team believes they need to see me. Another way to say that is some kids only see me when I take them in, and they see me on graduation because they are going to school. Other kids I see, I will tell you the truth, every other week I'm seeing them. We try very hard not to pull them out of school, and may just meet with the parents. If we feel the kid needs to be here, they do get an excused absence. Typically, we see our kids later in the afternoon. The high schoolers are easier to see later in the afternoon. They get out of high school by 2:30, 2:45, but we work really hard so they're not pulled out of school. And we work really hard with parents so that they're not missing work. The one good thing about the pandemic is we've all learned how to meet remotely, and that is even an option for families to participate remotely. And the last thing I'll say, at least with our program, there are informal status conferences held with the truancy court team. They don't see me, but they'll do it by telephone, parents and the staff, just as a check-in. So I hope that answers your question.
Yes, thank you.
Mm-hmm.
Delegate Davis.
Thank you, Mr. Chair, and thank you, Your Honor. You do acknowledge that the school to prison pipeline does exist. There's certain things that contribute to kids ending up in jail.
Yes, and I understand that. Yes.
Okay, and was this Kent County only?
I am representing Kent County only. Yep, Chestertown, the Upper Shore. Yes.
Okay, all right, and so Kent County is about 19,000 people. I can imagine that your subject group was pretty small.
We have 45 kids a year that go through our program. Compared to Prince George's County, Baltimore City, it's a small program. Yes.
Okay, thank you. And data is important, so you'll be sharing that?
Well, you tell me what type of data you need, and I'll make sure we get it to you. If you're looking for a correlation between kids that have come through my program and truancy and how many have ended up in juvenile court, I can get that with really quickly, more than likely. How other counties can get that, I don't know. But if I could just add to this prison to pipeline, my understanding is what propels a lot of that is suspensions. We have nothing to do with suspensions. That's the school. But I will tell you, we work with kids who've been suspended. Getting suspended does not kick you out of this program. It does not, it does not, it does not. We work with kids who have been suspended.
Thank you.
To me, those kids really need our intervention.
Delegate McComas.
Thank you, Mr. Chair. Judge Jensen, you've been doing this for 5 years?
Yep, I have.
And so we won't. So you've probably had 250 children if it's been 45 each year, kind of.
That's a good guess.
Approximately.
Okay.
All right. I didn't want to do the math, and I know Delegate Cardin's probably checking.
Although I would say of those kids, I've had repeats. So.
Right, but the point is you work closely with the school system.
I do.
And you know, if a kid gets suspended, then you guys kind of circle the wagons and work harder with the child, I suspect.
I guess that's a good way to put it. We don't learn of their suspension until we have a review hearing. We're told that they've been suspended. We don't go into why they've been suspended. But that's when we would get the information that they have been suspended. And yeah, I mean, I try to pick a little bit, understanding they have their own due process rights through the suspension process through school. And that's why I never want to get into it a lot during our truancy reviews, but try to understand what's going on. In order to be suspended, of course, they've got to be in school. So that's a good thing. They're in school, but it's their behavior in school that obviously is causing some concerns. But we try really hard to work with all kids, including kids who have a suspension history.
Well, Kent County is a small county, and I suspect that everybody kind of knows everybody, and that sort of helps the success of your program, I would think.
I would say that is true. Although I live in Caroline County and I come up to Kent County by choice, I don't have to do this program. But I think uniquely, because Kent County, like Caroline, are small, people do tend to have maybe tighter relationships and have they do collaborate pretty well.
And so basically, I know you haven't examined the statistics and the cases, but since you've been doing this for 5 years, if there were problems with the children going to prison, you know, because it is a small community, you'd probably know about that, correct? That there was that were in your program that was not successful.
Yeah. I mean, word of mouth travels. I mean, I can think of one young man who did not successfully complete the program, who got into some subsequent trouble. That's anecdotal. I know about that, but I don't think that was not driven by a school suspension or anything of that nature. These kids, as you imagine, the families, none of these cases are easy. It's layer upon layer of issues and barriers that help explain why school attendance is difficult for these kids.
But with your program, you're able to get them involved in resources, correct?
Yes. Local, it's called local care teams. Everybody around. Some of the biggest successes have been with getting families connected with Wraparound Maryland Coalition of Families that can directly work with families in the school with their kids. Yeah, we've got some really great community partners, and identifying by way of a needs assessment of families really helps us figure out what do they need to be successful. Sometimes it's as easy, believe it or not, as an alarm clock. And we give out alarm clocks all the time. They're the easy cases. As you go down the spectrum, there are a lot more harder nuts to crack.
Well, thank you. Thank you.
You're welcome. You're welcome.
Any further questions? That concludes the testimony on Senate Bill 668. Thank you very much.
Thank you.
All right. We're going to hear now from Denise Conway for Senate Bill 214. This is again as a departmental bill, and she will get 3 minutes, and there she is. So Ms. Conway, please.
Thank you, and good afternoon, and my apologies again for my technical difficulties. Chairman Clippinger, Vice Chair Moon, and committee members, I am Denise Conway, the Executive Director of Social Services Administration at the Maryland Department of Human Services, and I thank you for the opportunity to share the merits of Senate Bill 214. This bill authorizes disclosure of reports or records concerning child abuse or neglect to certain school personnel and the director of a licensed child care facility or a licensed child placement agency. This sharing of information ensures that children are protected across a multitude of disciplines serving children. Under the existing statute, Human Services Article 1-202, Child Protective Services may disclose abuse reports and records with certain professionals within the education system, as well as licensed child care facilities and placement agencies. Senate Bill 214 would expand the current practice to include the disclosure of alleged neglect. Dangers posed to children by individuals who engage in child neglect are just as significant as the dangers posed by individuals who commit child abuse. The proposed amendment would permit the Department of Human Services to share neglect reports with these employers. The added provision for disclosure of child abuse or neglect reports or records to a director of a licensed child placement agency expands the protection for children by permitting DHS to share information with the licensing agency so that the agency can take action to protect the child from maltreatment that may be caused by any caregivers in the home. I thank you for your time and consideration, and if you have questions, I would be happy to answer them for you.
Any questions? Delegate Arikan.
Thank you, Mr. Chair. So I just want to make sure I understand. Right now, are there other types of reports that are being shared, like with the daycare providers? So just neglect right now is not being shared?
That's correct. So a report that alleges abuse is shared, but we don't have right now the authority to share our neglect reports or records.
And would you say that there's significantly more neglect than there is abuse reports? Would this, how much would this, do you think, increase the reporting?
I would say that we do get a fair amount of neglect cases. Our abuse cases are tied to physical abuse and sexual abuse allegations, whereas in neglect, you have a variety of circumstances that would constitute a neglect consideration for investigation or assessment.
Okay, I guess I'm in my mind, I'm trying to think of how this plays out, and I'm not sure I'm personally totally comfortable with the idea of alleged neglect being sent to a daycare provider, because it's almost like it could end up being a hammer looking for a nail. Then there's an adversarial relationship that could develop between, you know, the parent who is alleged to have committed neglect and then the people that they're asking to care for their child every day. Something feels incongruous there to me. I mean, if they had been convicted of some kind of, I don't know, maybe other people feel differently. I'm not sure if this is going to help the child is what I'm saying. and it's only alleged. These are not convictions. So I'm not, is there a specific case that caused you to bring this bill forward?
There's not a specific case that I can give you right at the moment, but I would be happy to share with you some case studies that we have seen that were impacted by neglect.
Okay, yeah, anything you have extra, I would love to have it sent to my office. Thank you, Mr. Chair.
Absolutely.
Delegate McComas.
Thank you, Mr. Chair. Ms. Conway, I just have a question. Basically, this is if there's an allegation of child abuse and neglect. What if there was, okay, this does not consider foster parents, or in other words, it's just institutional, institutions like a group home or something like that. Is that correct? But it doesn't deal with like a foster parent or guardianship, but yet the the school, the Department of Social Services or the state has really the legal control of the child is where the child goes, is my question. Is that?
So this, I'm sorry, Delegate, my apologies.
No, I apologize for being inarticulate.
No problem. So this bill would expand to include education personnel, licensed child care facility, or licensed child placement agencies. And as you know, there are instances where child placement agency does work with our resource parents or foster parents. And so I think that's what you're asking me, but I'm not quite sure.
Well, I guess I'm asking, in other words, it would, the placement agency, but the foster parent would not be at issue, in other words, if there was a problem, but the state still had control of the child, is where the child went, is where I'm going.
So if there is an individual who wants to be a licensed resource parent, either with the agency or a child placement agency, they would undergo a background clearance. And I believe through those processes, your concerns would be addressed. So we would be ensuring that any child that is in the care of a resource parent, either licensed by the agency or the child placement agency, would have cleared all of those clearances. So we would not be placing a child in the home of someone who does have a history of child maltreatment.
Okay. Thank you.
Delegate Cox.
Thank you, Mr. Chairman. Thank you. All of a sudden, I can't see you on the screen. Ms. Conway, there you are. Okay. Appreciate your care and concern for our children. I have two issues. First, as Delegate Erickson mentioned, the allegations rather than the indicated findings being disclosed. I can understand an indicated finding being disclosed, but not mere allegations. That is a sincere concern. Is there any remedy in the works for that? Obviously, that wasn't discussed, I'm guessing, in the Senate.
To my awareness, that has not come up, and probably because currently we do expose allegations. I think that what I would ask you to consider is that we do recognize that an allegation is just that, and that we are going to conduct a proper investigation to, in fact, see if there is a finding of indicated, unsubstantiated, or ruled out allegations. And I think this is a level of awareness so that way an education system or the child placement agency is aware. And so if they were to choose to potentially do something such as place a person on like administrative leave or whatever that course correction would be while they await, I think we would leave that up to their discretion. But I think what we are trying to do is create a level of awareness, but not necessarily give someone child maltreatment history. They would go through the formal process of an investigation or an assessment.
Would the department be open to excluding ruled out and unsubstantiated findings and mere allegations? In other words, I had a case once where a foster mom who was foster mom of the year was had a neglect allegation that ended up becoming ruled out as if, as you know, never happened. It was a false allegation. Now, unfortunately, someone who did not, see eye to eye with her in the department or whatever happened, informed her new foster agency of this ruled out allegation. And the end result was she was denied her foster care license over a false allegation through this process. So I have a concern, is there any way would the department be open to a protection, some guardrails in that regard?
I think that is certainly unfortunate for that individual, and I'm sorry that happened to her. We have processes in place that guard us around making sure that those things don't happen. And so I hope that is an instance that does not happen frequently. And when someone has an indicated or an unsubstantiated finding around child maltreatment, that is what should be reported. We have an appeal process that the individual can go through in instances where there is child maltreatment found. And so I would like to think that when we are clearing someone for child maltreatment, that those instances that you have described are a rare circumstance.
And lastly, my final question is, if a teacher sexually abuses someone, one of their students, as has happened in Maryland, sadly, this bill wouldn't apply to that situation, would it? Because it's not in a home. The bill's very specific that says the abuse happened or neglect happened in a home committed by a household member, a family member, or person responsible for supervision in a home. Is that your understanding?
So our definitions around who could be determined to be a maltreatment are those individuals that have the care and custody over a child. And so an individual who works in the education system and is in fact identified or could potentially be identified as a maltreatment as a child is in the care and custody of that individual. And my experience has been that school personnel are in fact investigated or assessed by the local departments of social services. And in fact, if there is a case such as you've described where sexual abuse is alleged by a professional, we would in fact investigate that case.
Well,
that is already taken into consideration in the current statute because it is defined as an abuse case and not a neglect.
And I would agree with you. I'm not saying you don't investigate it. I'm saying this bill that says you would share the information, it would not be shared in that circumstance necessarily because the law doesn't authorize that. It's not abuse or neglect in a home. That was my question. Is that your understanding?
Oh, I'm sorry, Delegate. So currently, cases of abuse are already, we already have the authority to share that information in cases of abuse. What we are trying to do is add cases of neglect to the statute.
Well, I'm talking about where the abuse and neglect occurred. I just leave it at that. I think maybe, I don't know if you're open to working with the committee, but maybe there's some guardrails. But thanks so much for your time.
Sure. Absolutely. And thank you, Delegate.
Further questions? Seeing none. That concludes the testimony for Senate Bill 214. We thank you very much. We're going to go now to Senate Bill 203 committee. It is 142. We're going to hear from Janet Hartke, please, for 3 minutes. Is she here yet? There she is, connecting to audio. Hartke.
Yes.
Please, for 3 minutes on Senate Bill 203.
Chairman Clippinger, I am here for technical support for Miss Denise Conway, and if the panel has any, if the committee has any questions regarding the interplay between the legislation and the.
All right. So all right, then we'll call Ms. Conway back and for Senate Bill 203, if she's able to speak about that. Ms. Conway?
I'm still here.
Okay, first, can you present Senate Bill 203, please?
Absolutely.
All right.
All right. Thank you again, Chairman Clippinger, Vice Chairman Moon, and committee members. As you all know, I'm Denise Conway, the Executive Director. On May the 10th, 2021, the Children's Bureau notified the state that we must comply with Section 4755B of the Social Security Act, which requires that status of every child in foster care be reviewed every 6 months. These hearings are required to determine the safety of the child, the continued appropriateness of current placement, and compliance with the current plan for the child and family, in addition to the status of addressing or mitigating the reasons for placement in foster care, and a projected date that the child may be returned home safely or placed for adoption or legal guardianship. In addition, for older children who are expected to remain in foster care until adulthood, these review hearings are required to identify the opportunities for the youth to engage in activities such as sleepover with friends, social events, school-sponsored field trips, and scouting, because these things normalize their lives and maintain their health, safety, and well-being, as well as assist in developing valuable life skills for them. So these proposed amendments would ensure that Maryland's compliance with federal and statutes and regulations. Implementing federal mandates is critical for Maryland's federal funding retention and will more importantly ensure that we are regularly partnering with children, youth, and families around achieving lasting permanency. As Ms. Hartjee shared, she is here to help me with technical assistance, and I welcome any questions that you have in relation to Senate Bill 203.
Delegate McComas with a question, please.
Thank you, Mr. Chair. Ms. Conway or Ms. Hartich? Quick question. If we don't pass this bill, does the state of Maryland lose buku money?
That is correct. We have been advised by that we are in danger of losing money if we don't pass this bill.
And approximately how much money?
So it would be our foster care reimbursement for the 4E funds for children in foster care, because as they're reading our current statute, we're not requiring 6 months hearings for every single child.
And that's going to improve the care and maintenance and health and development of these children, correct?
Certainly 6-month review hearings are important and critical for children in foster care so that their permanency stays on track, and we look towards permanent solutions for all children in foster care. And we're ensuring that they have the appropriate opportunities to participate in various activities.
Okay. And if we didn't get the money, and if we didn't do this, it's going to have, in other words, it will harm the children, not help them.
Correct.
And there's no cost to the state of Maryland.
There is no cost in passing this. That's correct.
Thank you very much.
There's only a benefit.
Further questions for the panel? Seeing none, we thank you all very much, and that concludes the testimony for House Bill, I think, 203. All right, we're going to see who we've got here. I see Senator Lamb here, so why don't we go ahead and take Senator Lamb. We'll do Senate Bill 820. I think this was cross-filed, so we're only going to hear from Senator Lamb, and we're going to hear from him for 3 minutes. So Senator Lamb, go ahead.
All right, thank you, Chairman Clippinger. So good afternoon, members of the committee. For the record, Clarence Lamb, Senator District 12. The purpose of SB 820 is to address the concerning repeat audit findings within the Department of Human Services that relate to child abuse and neglect investigations by creating a temporary reporting structure and workload analysis to guide future legislation to solve the problems that we're seeing in these audits. The committee has already heard the House cross-file of this bill. However, the bill is amended in the Senate. The House sponsor has agreed to conform their bill to the Senate bill that is before you now. As the committee is aware, the local Department of Social Services or local law enforcement must attempt to see a child or decide on the safety of a child within 24 hours after receiving a report of suspected physical or sexual abuse, and within 5 days of receiving a report of suspected child neglect or mental injury. And to the extent possible, a child abuse or neglect investigation must be completed within 10 days after receiving the initial notice of suspected abuse or neglect. This bill stems from an unfortunate long-standing problem with the Department of Human Services and its ability to properly track and complete child abuse investigations in a timely manner. As the Senate chair of the Joint Audit and Evaluation Committee, this has been a concern that we've seen from our Office of Legislative Auditors, who has brought it to our attention repeatedly. In my written testimony, we have provided a link to the audit that compels this legislation, and we understand that while there are significant concerns relating to staffing and resources within our local social services departments, this bill is not meant to denigrate the tremendous work that so many of our social workers and law enforcement entities are engaging in to protect the welfare of Maryland children. The bill is meant to provide the General Assembly with more regular insights, as well as periodically scheduled audits to inform their future policy proposals to strengthen our state's social service infrastructure. The bill will require local Department of Social Services that fail to conduct child abuse and neglect investigation within the time frame to report the delay and the reasons for that delay in a timely manner to their supervisor. The local Social Services Department would also be required to report annually to the legislature on the progress of their compliance within the statutory timeframes of conducting these investigations and reports, as well as a quarterly report that's made available to the public. It would authorize licensed professional counselors to help local social service departments to conduct these investigations. And the bill also directs DHS to conduct a workload analysis to better understand the reasons for understaffing issues and how these might be addressed in future legislation. There's a reporting function back to the appropriate committees. Overall, children have reported incidences, children with reported instances of abuse and neglect against them represent some of the most vulnerable populations in the state. And while this does not directly solve that problem, it will add to our statute a more robust oversight process for why these delays are occurring, ensure that we can address these repeat audits that are coming up and so they're not lost in the shuffle, and allow the Joint Audits Committee to continue monitoring the issue. With that, let me wrap and happy to answer any questions from the committee.
Delegate Crutchfield, please.
Thank you, Mr. Chair, and thank you, Senator Lamb. Could you just tell us really quickly again how the amendments changed the bill?
The amendments changed the bill, I think, by adding licensed professional counselors. It also strengthened some of the reporting requirements, and I think also requests that they conduct a workload analysis to better understand the reasons for understaffing. And in communicating with the House sponsor, she's agreed to conform that bill to the Senate version that's before you now.
Thank you so much, Senator Lamb.
Sure.
Any other questions? Seeing none, that concludes the testimony for Senate Bill 820. Thank you very much, Senator Lamb.
Thank
We're going to go to Senator Watson's aide for Senate Bill 884. Could we have Senator Watson's aide, please? All right, Mr. Holmes. All right, you're presenting Senate Bill 884, please. So go ahead, you have 3 minutes.
Thank you. For the record, my name is Brendan Holmes, legislative aide to Senator Ron Watson. Senator Watson sends his regards to his good buddies over here in the Judiciary Committee. Chair Clippinger, Vice Chair Moon, and the members of the Judiciary Committee, thank you for the opportunity to present this legislation before you all today. Can you all hear me? Good. Okay, thank you. SB 884 is a simple and straightforward bill that makes an exception to the driver's license suspension statute for child support obligors making less than 300% of the federal poverty level. Mobility is key in Maryland's regional economy. The Census Bureau reported that in 2019, that almost 50% of Marylanders travel outside of their county for employment. This statistic is more pronounced for lower income communities of color, where there's a scarcity of jobs available by public transit. For example, only 9% of jobs in the Baltimore region can be reached within 1 hour with a one-way by public transit. Moreover, many employers in these communities won't hire individuals without a valid driver's license, as driving is central to the position. In 2015, NPR reported that 62% of Marylanders who owe child support make less than minimum wage, but owe at least $10,000 in unpaid arrearages. They would never pay down this debt, especially when the current law magnifies this issue by crippling their mobility. As such, Maryland should pass Senate Bill 884 to repeal driver's license suspension as a penalty for obligors who make less than $39,000 per year, which is 300% of the federal poverty level. License suspensions for workers at that income level cannot be considered appropriate or increasing effectiveness, as it is, 1, waste taxpayers' dollars in collection enforcement, 2, prohibits and eliminates access to employment for workers and job seekers, and 3, heightens tensions between the custodial parties, which in turn decreases compliance rates. SB 884 received a favorable ruling in the Judicial Proceedings Committee and also received a unanimous vote of 46-0 on the Senate floor. And for these reasons and many more, I respectfully urge for a favorable committee report on SB 884. Thank you very much.
Keeping in mind, this is Senator Watson's aide. Questions, Delegate Cox.
Thank you, Mr. Chair, and please give our shout out to the good senator, Mr. Holmes. And real quick, how do people pay their child support? What's the source for cash?
I'm sorry, could you repeat that question?
How are individuals able to make their child support payments? Through money, right?
Yes.
And then I'm actually supportive of what you're saying, because then the second aspect is, well, how do we make money?
Oh, well, of course, through working, through wages, through our jobs.
So it's to me, it's a reverse and almost an asinine position to take away the license for somebody to be able to go to work to pay their child support. Would you agree that that's not appropriate for the importance of the child support payments?
Of course, especially considering the fact that there are other mechanisms that are in place that are much more effective in gaining money and compliance in terms of child support as well.
Thanks so much for your time here.
Further questions? Seeing none, we thank you very much. And that concludes testimony for Senate Bill 884. Here's Senate Bill 435 next. Senator Huff's aide, I believe, is here. If we could have Senator Huff's aide brought in, I'd appreciate it. Mr. Vandervoort. Mr. Vandervoort, Mr. Huff's aide, Senator Huff's aide. Here for Senate Bill 435.
There
we go.
Okay, sorry about that. Yes, my name is Robert Vandervoort. For the record, I'm the legislative director for Senator Huff, and he regrets not being here. And so with that, I will present the testimony he would have given. And Mr. Chairman and members of the committee, we respectfully request that you pass SB 435. It eliminates the statute of limitations for preventing or interfering with the reporting of child abuse or neglect. Currently, failure to report suspected abuse or neglect of a child is considered a misdemeanor with a 3-year statute of limitations. The problem we want to resolve is any institution or individual who thwarts the proper reporting of suspected child abuse. Eliminating the statute of limitations for this crime will help keep our kids safe. And for all these reasons, we respectfully request that you give SB 435 a favorable report. That concludes our testimony.
Thank you. This bill wasn't cross-filed, so we're going to hear from Lisa Jordan for 2 minutes.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 435 with amendment. We, of course, agree and appreciate Senator Huff's work to hold offenders accountable, but we do ask that if the committee chooses to report on this bill, it should be amended to make the crime a felony. From MCASA's point of view, the two most important reasons to make something a felony are that it expands the statute of limitations, but also that it keeps firearms out of the hands of dangerous people. Senate Bill 435 is an effort to expand the statute of limitations in these criminal cases without creating the important collateral consequences by using the Courts and Judicial Proceedings 5-106B. And while that may be appropriate in some cases, we believe it is not in this case. MCASA absolutely appreciates and supports the hesitancy to create more felonies without a doubt. We want to be very clear that we appreciate the Judiciary Committee's work in that area in general. However, In this case, we ask that the committee make preventing or interfering with a report of suspected child sexual abuse a felony in order to impose those resulting collateral consequences. I'm confident that the members of this committee recognize the heinous nature of interfering with a report of child sexual abuse and would not want to protect someone convicted of this horrible crime. For those reasons, we do ask for an amendment to make this a felony and report favorably on Senate Bill 435 with amendment.
Thank you. Are there any questions? Delegate Cox.
Real quick, Bob, good to see you, sir. So with this particular waiver of the statute of limitations, has there been any testimony in the Senate as to the impact on civil cases that also seek to go back and remove the statute of limitations? For instance, someone passed away, 50 years ago. Is that going to now allow for prosecution, then per se civil liability for the institution?
Well, Delegate, my understanding is that this just applies in criminal matters. That's something I'd be happy to go back and look at and research and get back with you on. But it's my understanding that that this is just on the criminal side of things.
If you could double check on that for me, because my understanding of per se civil liability is obviously can hinge upon criminal liability. So anyway, thanks so much.
Delegate Bartlett.
Thank you, Mr. Chair. My question is for Lisa Jordan real quick. What doesn't this has to be like, I'm trying to understand what interfering with the report or making a report, what it looks like. I mean, it would have to be something, pretty done in a bad, in a strong, clear way that's what they were trying to do. Do you mind, can you give an example of like what that looks like?
Yes, thank you, Delegate Bartlett. So this really was an effort to look at supervisors of social workers or clergy members or people who knew that child sexual abuse was happening and were told by their superiors, for instance, by a bishop or by a boss, that they should not report the child sex abuse. And unfortunately, there were some children who continued to be abused. There were some offenders who were moved from one employment location to another location where they continued to abuse children. So this is not aimed at the abusers themselves, who of course already have a felony against them, but against the people who are really helping the system prevent the offender from being caught and prevent the abuse from stopping.
Thank you.
Delegate Howell.
I really think that Delegate Bartlett, good evening, everybody. I really think that Delegate Bartlett probably asked the same question that I was going to ask. I was just going to ask who would be a person that would be withholding this type of information. But I think that Ms. Jordan answered that question. So thank you.
Any further questions? Seeing none, that concludes the testimony on Senate Bill 435, and we thank you both very much. Now we're going to hear the final bill, House Bill 1418. This is Delegate Rachel Jones's bill. There are several witnesses. 3 minutes for Delegate Jones, 2 minutes for everyone else. And I'm going to ask that they all are brought in. Brett Engler, Catherine Marsh, Jessica Garth, Lisa Jordan, and Debbie Feinstein. Delegate Jones, go ahead for 3 minutes.
Thank you, Mr. Chair, and I will take less than that. So this is House Bill 1418, Marriage Confidential Communication. The purpose of this bill would be to allow a spouse to disclose confidential communication between spouses that occurred during their marriage in the event that one spouse is charged with a criminal action against the other. So this bill would be in line with many other states. It would empower domestic violence victims and hold abusers accountable for their actions. It would make it so that one spouse would be able, even if the crime or the abuse happened during the marriage, but they're, let's say they're now going through a divorce, the divorce has happened, they would be able to share communication, whether it was a conversation or text message, email exchange that happened that verified the abuse that had occurred or whatever the criminal charge is. And so I think that this will be very, very helpful for some of our Marylanders who are going through domestic violence situations, and because of spousal communication privilege, they are not able to, in their defense, use a bit of a conversation that may prove that the actual assault or abuse or crime against them did happen at the hand of their spouse. And I urge a favorable vote. Thank you.
Okay. Brett Engler, please, for 2 minutes.
Hello, members of the committee. My name is Brett Engler. I'm the Chief of Domestic Violence at the Frederick County State's Attorney's Office. On behalf of my office and the MSAA, I urge a favorable report on House Bill 1418. Maryland is one of only a handful of states that do not have an exception to the marital communications privilege when one spouse is charged with a crime. Marital communications privilege is held by both spouses. So, for example, if a husband is charged with beating his wife, the wife, if she so chose, could testify against him, but she could not share apologies or communications that would verify that, in fact, the husband did rape, beat, assault her, commit a crime against her, unless the husband waived the privilege. So, as prosecutors, when you're dealing with crimes that happen within the home and between two people in secret, abusers abuse in private, a critical piece of evidence is a confession to your victim, a promise to never do it again, an apology. It keeps the victim in the cycle of violence by having that. When the victim is ready to testify and come forward, we can find ourselves in a situation where the offender denies the abuse, takes the stand, says he didn't do it, someone else perhaps did it, and the victim could literally be sitting there with the state's attorney's office, with her victim representative from a domestic violence shelter, and not be allowed to share the fact that this happened, and she can prove it happened, and the state can prove it happened with a written apology from the husband to the wife during the marriage. Husband could take the stand and say she's a liar and effectively be fraudulent towards the court and the jury because he and she hold the privilege. So this law would ameliorate that. We are one of only a handful of states that does not have this very important exception for victims of domestic abuse and other serious crimes that can occur between married people. So I do urge a favorable report. Specifically, I'll point the members of the committee to State versus Enriquez. That was in 1992, 327 Maryland 365. The husband was charged with raping his wife, and the Court of Appeals held that under the fact that we do not have an exception to the marital communications privilege, the wife was incompetent to share an apology. And the husband was obviously convicted, and he appealed that and won. She was incompetent. Thank you very much. We do need to change that. Thank you.
Thank you. Catherine Marsh, please, for 2 minutes.
Thank you. Good afternoon, Chairman Clippinger and members of the committee. My name is Catherine Marsh. I'm the Special Victims Liaison for Charles County, and I'm here on behalf of the Maryland State's Attorneys Association. Intimate partner violence, domestic violence accounts for 15% of all violent crime in this country. And this number doesn't even take into account the psychological, emotional, and economic abuse that's often part of these crimes. So often in our cases, verbal threats or text message threats are made to the victim prior to the physical abuse. And after the abuse, we often see remorse or communicated apologies. When a couple is not married, these statements may be admitted at court. If the couple is married, the abuser can prevent the victim from admitting these statements as evidence. I've had cases when an abusing spouse sent threatening text messages to harm the victim prior to the assault and then carried out the assault. The text messages were barred from admission in court. As Ms. Engler just mentioned, the Court of Appeals and State v. Enriquez actually said that for a change to the marital privilege communication, for an exception to happen, it needs to come from this legislature. And that's what this bill does. When a victim wishes to proceed in a criminal matter against their abusing spouse, it will be the victim and not the defendant who would hold the privilege. The victim cannot be compelled to divulge marital communications, but rather they can waive the privilege if they wish regarding communications about the crime that was committed against them. This will help provide balance to a power and control dynamic of intimate partner violence. The marital communications privilege was designed to protect the sanctity of marriage. But when the sanctity has already been violated by an abusing spouse, it is instead being wielded as a weapon, barring the victim from providing evidence of that abuse. As you've heard, Maryland is one of only a handful of states that does not recognize an exception to the marriage communications privilege when it comes to crimes being committed by one spouse against another, and that needs to change. I urge a favorable report of this bill.
Thank you very much. Jessica Garth, please, for 2 minutes.
Good afternoon, Mr. Chair and members of the committee. My name is Jessica Garth. I'm the chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here on behalf of the MSAA and State's Attorney Aisha Braveway to urge a favorable report on House Bill 1418. Under the current legal scheme, a defendant can prevent his or her spouse from testifying about these confidential communications on any type of case, including cases in which that spouse is the victim. This creates issues. It allows victims who would otherwise be able to testify as to these communications to be silenced by their own abusers. It excludes relevant evidence from cases at the will of the defendant, and it creates an inequity for victims who happen to be legally married to their abusers, as opposed to victims who are in other types of relationships or no relationship at all. House Bill 1418 places the power in the hands of the victim's spouse and would allow the victim to choose whether or not to invoke the privilege. It would, without a doubt, increase our access to relevant and powerful evidence to use at trial in prosecution of these types of crimes. As my colleagues have said, the vast majority of states already include this exception under the law, and it is time for Maryland to join that list. In the interest of justice and the interest of fairness, I urge a favorable report on this bill. Thank you.
Lisa Jordan for 2 minutes, please.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here to urge a favorable report on House Bill 1418 with the sponsor amendments. I'm not going to repeat the testimony of the prior witnesses, but we did want to emphasize the importance of the sponsor amendments, the importance of leaving the decision about whether or not to testify in the hands of the victim. The dynamics of domestic violence include power and control, and allowing the victim to decide whether or not to testify helps to end this cycle of abuse. Note that several of my colleagues have submitted written testimony in support of this bill with these amendments. I drew the short stick, providing me with the honor of presenting oral testimony today, and we just sent one person in the interest of time and where we are in session. So just please know there's broad support for this approach to changing the marital privilege when there is a crime against the spouse. For these reasons and for the reasons expressed by the other witnesses, MCASA urges a favorable report on House Bill 1418 with the sponsor amendments.
Debbie Feinstein.
Good afternoon. Thank you, Chair Clippinger and members of the committee. My name is Debbie Feinstein. I'm Chief of the Special Victims Division in Montgomery County, and I'm also Chair of the Maryland States Attorneys Association Subcommittee on Domestic Violence and Power-Based Violence. I'm essentially saying me too. I don't want to repeat the testimony of my colleagues. However, I also want to distinguish for those of you that are familiar with the other marital privilege or other privilege that relates to individuals that are married. This privilege is separate and apart from what we know as the marital privilege, which we also know as the marital privilege, which is that one spouse cannot be compelled to testify against the other spouse except under limited circumstances. For example, if it's about child abuse or if they have previously invoked their privilege not to testify against their spouse in a domestic violence case. This is different. We are not looking to take the power out of the hands of the survivor victim. We're actually looking to empower them so that they can have the choices all in front of them and take those choices from their abuser. I would urge this committee to issue a favorable report on this bill and to take that power away from the abuser and put it squarely in the hands of the victim. Thank you so much. I urge a favorable report.
Questions now, Delegate Carden.
Thank you very much, Mr. Chairman. Just quickly, I guess this is for Ms. Feinstein or Ms. Engler. So first of all, doesn't this privilege not actually, or there can be a way to get around the privilege if you're impeaching the person on the stand for something that they said that would normally not be able to be, it would not be able to be used, but if they said something that you believe is impeachable, that you could use this or not. I guess that's not a exception to it.
Yeah, I'm not aware of an exception to it. It certainly would be judge by judge, and case by case. You'd have to try to argue that the offender's essentially perjuring himself so that we can see somehow that he's waived it. I actually did see a case kind of relative to that, but it's not exactly on point. I mean, the communication was to a third party as well, someone overheard, certainly there are ways to have waived the privilege, but I'm not aware the offender clearly holds the privilege over the victim.
So this is only for communications with the victim, right? Is that my understanding?
Right, because if it wasn't with the victim, then it wouldn't be confidential.
Wouldn't be privilege. And my final question is, what other states still have this privilege as we have it here in Maryland?
The only states that I'm aware of, I did have a wonderful intern do a big study for me. This was about 1.5 years ago or 2 years ago. Missouri, North Carolina, Pennsylvania, Rhode Island, South Carolina, and Maryland is one of those. There's a few that have it kind of in case law, and we were unsure about West Virginia, we were unsure about Michigan, but literally every other state has this in their law, in their evidence code.
Thank you.
Thank you.
Further questions for the panel? Seeing none, that concludes the testimony for House Bill 1418 and our bill hearings for today. It's 2:15 committee. The floor begins at 2:30. You should begin to head over there now. Thank you very much.